distinguished guests, it is a great honor to be here present at the Ludovica University of Public Service today on the second day of our conference, Natural Law for Real-Life Problems. As the commencement of today's program, let me give the floor to the Vice Rector for International Affairs of this university, Pier Paolo Pigozzi. The floor is yours.
Thank you. Oh, dear friends, colleagues, guests, as Vice Rector of the Ludovica University of Public Service, I have the pleasure, and it's a real pleasure, to welcome you to one of the warmest venues in our university. A special welcome goes to our keynote speakers of these days and the guests from abroad. Our institution is one of the most important regional knowledge centers and the #1 Hungarian higher education institute for public service, public administration, diplomacy, security, law enforcement, and water management. The Ludovica University of Public Service also defines itself as a university of cooperation. We are implementing an effective model of cooperation between social needs, national strategic governmental goals, and higher education. Committed to these goals and to science, we contribute to the development and application of new knowledge through our research institutes and research groups. Beyond this, developing international partnerships is one of the strategic goals of the university. As part of our internationalization efforts, we manage the Ludovica Scholars Program, the Ludovica Fellows Program, to which you are all invited and welcome to apply. It will be a pleasure to have you more time here with us. We also encourage the application of students through the programs of Stipendium Hungaricum, as well as the exchange programs of Erasmus and Erasmus Plus programs. It is central to the mission of our university in the service to the Hungarian nation to cultivate the riches of our Christian inheritance. Therefore, there is no better place to welcome you to the second day of this great event. In this spirit, I hope that today the event will provide us with many important lessons and a fruitful exchange of ideas and experiences. Thank you for your attention and welcome to the university.
And now we have come to the very first panel of today's program. And within this program, titled Human Rights, Adjudication and Natural Law, we will have Pier Paolo Pigozzi, the Vice Rector, as a moderator, and we will also have Conor Casey from the University of Surrey, where he is an assistant professor for public law, and we also have Gonzalo Candia as a presenter from the Catholic University of Chile. Conor Casey is going to present about natural law interpretation of the European Convention on Human Rights, and Professor Candia is going to present on international law and human rights adjudication. Let us welcome the presentations.
Good morning, everyone. Before I begin, I just want to thank the organizers of this just superb conference, Kalman, Ferenca, and Joanna. And more generally, I want to thank the MCC and its staff for hosting me so generously these last several weeks. So today I'm going to make the case for an alternative interpretive approach to the European Convention on Human Rights, one that is consistent with basic axioms of the classical natural law tradition. So I'll divide my remarks into 4 parts. First, I'll give a flavour of the core components of the court's current methodology. Then I'll discuss why I think this methodology is in tension with the thrust of the classical natural law tradition's treatment of judicial power and basic tenets of good government. And then I'll outline an alternative approach And the foundation of my alternative approach rests on the jurisprudence of the European Court of Human Rights, perhaps most heterodox judge, a British judge called Sir Gerald Fitzmaurice, who was the UK's judge from 1974 to 1980. In his dissents and concurrences, and there were many, I argue there are the seeds from which a more promising approach to interpreting the Convention can be sown. But I forewarn you, I will end on a very gloomy note. So, a few words on the court's current approach, which really took off in the mid-1970s. At this time, the court radically altered its approach to interpreting the European Convention. In simple terms, the court departed from seeing its role as being the enforcer of the actual bargain struck by the signatory states in the legal propositions they agreed in the Convention. And instead, the court began to see itself as the conscience of Europe, a tribunal whose job was to continually update the legal content of the provisions of the Convention to keep pace with the changing moral, cultural, and social practices of the member states and shifting moral consensus of the peoples of Europe. So the core methodological commitment of the court around this time became to view the Convention as a living instrument to be interpreted in light of present-day conditions. So the court today, following the adoption of this methodology, is not particularly concerned if their doctrinal innovations frequently have a slim basis in the text and structure of the Convention, or the fact that travaux preparatory of the Convention might show the drafters and ratifying states were very confident that the scope of a particular provision did not extend to cover a certain policy area or issue. The main pace setter for the court's dynamic interpretation of the Convention is the presence or absence of what the judges call a European consensus. This impressive sounding phrase functionally means something quite simple, even crude, namely that a majority of the court on the day now happens to think there is a sufficient convergence in the domestic laws of the member states around a particular topic. So if enough member states think that euthanasia is part of private life, then euthanasia is part of private life. It can be that functionally, that crude. Now, why is this problematic from the perspective of the classical natural law tradition? Well, I think it's in tension with some basic principles in that tradition is articulated with reference to judicial power and prudent government. For instance, it's in tension with the idea the appropriate role of the judge is to apply pre-existing legal commitments to resolve disputes and not engage in prospective rulemaking for the community. It's also in tension with the proposition judicial respect for the choices of the lawmaker, those charged with care and responsibility for the political community, means that they should strive to discern the reasoned choices and intent of the lawmaker as opposed to projecting their preferred meaning onto legal materials. Finally, it's in some tension with the classical notion that human rights law represents a specification in positive law of what is owed to persons as a matter of justice because of fundamental truths about the normative equality of the human person. The court's approach instead casts rights as liberties and immunities needed to respect individual autonomy to shape up one's own subjective view of a worthwhile life, all the while subject to the shifting moral sentiments of society. So a strange combination of emotivism and conventionalism. So is there an alternative? I think there is, and I offer for your consideration today a method of legal interpretation I call the Sir Gerald Fitzmaurice option. As mentioned, Sir Gerald was the UK's judge on the court from 1974 to 1980, right around the time the Strasbourg court embraced the living instrument approach. And Sir Gerald is perhaps best known for his dissents while on the court. Out of all the cases he sat on while on the court, he dissented in over 75%. And most of these dissents were pushing back against what he considered to be an unprincipled expansion of Strasbourg jurisprudence. So a quick biographical note. He was the third judge appointed by the United Kingdom to the court. Before becoming a judge, he was a barrister who served mostly in the Foreign Office in the UK government. He offered distinguished service in that role through World War II and represented the UK at the San Francisco and Paris Peace Conference. And immediately before being appointed to the court in Strasbourg, he was the UK's judge on the International Court of Justice. I do not have time to go into all his dissents and concurrences because there are so many, but I'm going to try and give an impression of his basic approach through focusing on two seminal cases Tyre in the United Kingdom, and Marx in Belgium. One from 1978, one from 1979. So Tyre concerned the interpretation of Article 3 of the European Convention, which categorically states that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. So the question before the court was whether this categorical prohibition was contravened by a statute in a region of the United Kingdom, the Isle of Man, that permitted a judge to sentence a young offender in lieu of imprisonment to corporal punishment in the form of 3 strokes with a birch stick. A birch stick is a bundle of leafless sticks tied together and had to be a certain length and width. The punishment was administered with clothes on, by a police officer and in the presence of a medical doctor. And it was 3 swishes of the birch. The question was whether this was against the categorical prohibitions in Article 3. In deciding by 6 votes to 1 the birching as a punishment was contrary to Article 3, the court basically held that in any instance, any form of corporal punishment was such as to bring it into the realm of degrading punishment, absolutely prohibited by the Convention. And Tyre was the first case where the court actually used the phrase living instrument to describe the Convention, holding that its provisions must be interpreted in light of present-day conditions. In practical terms, in the context of this case, this meant the court held it could not, quote, but be influenced by the developments and commonly accepted standards in the penal policy of the member states of the Council of Europe when it came to assessing whether a particular punishment fell within the ambit of Article 3. And as Professor Finnis has pointed out in his writing on this case, what the court was doing here was not applying the legal principle chosen by the adopters of the Convention to perhaps novel or unanticipated conditions or questions, but replacing the substance of the principle and the threshold which the signatory states regarded the seriousness of the activity caught by Article 3 in favour of present-day and judicially shared value judgments about penal policy. And so perhaps the central critique of Sir Gerald's dissent was that his colleagues had elided the substance of the term degrading with undesirable, and that respect for the terms of the Convention had, in his words, been subordinated to considerations of legal policy and judicial views of its desirability. So Sir Gerald, of course, agreed that states should be held to the absolute prohibitions imposed by Article 3, but thought that his colleagues had gone awry in discerning the scope and gravity of the kind of activity it prohibited. Now, as with his other dissents, his approach involved construing the Convention in a manner analogous to other deliberately created legal instruments, like contract, like statute, by trying to discern its intended meaning and import, by reflecting on the ordinary and natural meaning of the text, is informed by the rich socio-historical context of its drafting and enactment. And for Sir Gerald, the fact that Article 3 was drafted with an eye to preventing the kind of torture and degradations inflicted by the fascist and communist regimes of the 20th century was a critical socio-historical context for setting Article 3's threshold for how to understand whether punishment or treatment was truly inhuman or degrading. So simply put, in Sir Gerald's mind, Article 3 was intended to address much more serious things than those in issue in Tyre, by which he meant the type of treatment meted out by the state that is entirely inconsistent with the natural law's prohibition against, for example, treating the human person like an object, or a subhuman animal, or a science experiment, or a chattel slave, all of which occurred during the Second World War and was very much in the minds of the drafters. And Sir Gerald simply did not think that the kind of birching judicially administered in Isle of Man following a fair trial and conviction for a criminal offence met this kind of threshold. So that's the first case. Second case is Marx in Belgium. Marx concerned the legal position of a Belgian child that was born outside of wedlock. So under Belgian law at the time, a child born outside of wedlock was only recognised as the child of the mother if the mother, in her discretion, recognised the maternity. And a child that was recognised by the mother still had moderately less favourable rights when it came to questions of succession and intestacy. They didn't immediately gain intestacy or succession rights when it came to the wider family circle, for example. So the question was whether this was a breach of Article 8. And Article 8 of the Convention says, everyone has the right to respect for his private and family life, his home, and his correspondence. Now, the majority found these statutes to be a breach of this provision. And what really irked Sir Gerald in this case was that the court spent vanishingly little time, basically skipped over the question of discerning the scope of Article 8 and what fell within its ambit and what didn't come within its ambit. The court basically just assumed anything. Does this look like a family? Is there a personal relationship? Okay, Article 8's engaged. Let's talk about whether it's reasonable or unreasonable. And Sir Gerald's objected strenuously to this lack of concern for methodology. For Sir Gerald, it was extremely important to be rigorous when addressing the threshold question of whether a provision of the Convention is engaged in the first place, and not to rush ahead into questions about whether the exercise of the right has been justly regulated or not. So how to properly discern the scope of a provision like Article 8? Like in Tyre, the dissent offered interpretation of Article 8 grounded in text, structure, and socio-historical context. Sir Gerald argued that if one reflected on this context, that, quote, the main, if not indeed the sole object and intended sphere of the application of Article 8 was that of the domiciliary protection of the individual. And by this, the judge meant protection from the kinds of government activity and tactics well known to those drafting the Convention in the post-war era that were directed by governments toward invading and controlling the most intimate, the most familial, the most personal kinds of spaces and types of communication. So Sir Gerald said the protections of Article 8 were designed to counteract things like arbitrary searches in the middle of the night, the confiscation, the screening of correspondence, the planting of listening devices, what Sir Gerald compendiously called the whole gamut of fascist and communist inquisitorial practices prevalent in many countries between the two world wars and subsequently. The object of Article 8, thus construed, consequently meant that its object simply did not stretch to encompass the internal domestic regulation of family relationships, like whether, like the differentiation of treatment of children born within or outside of wedlock. If the drafters did wish for Article 8 to encompass these types of legal questions, they could have easily expressly included them within the ambit of the article, like they did with questions concerning family life, marriage, family formation in Article 12 of the Convention. The court's judgment had, he concluded, risked the inflation of Article 8, quote, in a manner and to an extent wholly incommensurable with its true and intended proportions, placing obligations on the signatory states they never agreed to, and vesting legislative responsibility upon the court that was never intended to be vested in them. And since then, the march of Article 8 has been, you can only describe it as imperial, and I think Sir Gerald's remarks were very prescient. Okay, so what are some of the core features, to tie it together, of the Sir Gerald Fitzmaurice approach? Well, the object of interpretation would be to discern the reasoned choices and intentions of the signatory states in promulgating the terms of the Convention. The scope and substance of those choices and intentions falls to be discerned like construing any deliberately created legal instrument, primarily by close focus on the ordinary meaning of the terms of the Convention construed against the rich socio-historical legal context of their drafting. This context can include recourse to the drafting history and travaux where it is clear, but more generally it will involve reflecting on the evils and mischief the Convention was designed to prevent and combat and the goods it wished to instantiate, which was to create really a firm baseline of protection for the human person and family unit from the atrocities, barbarities, and tyrannies characteristic of the totalitarian regimes of the 20th century. And the rich context of the Convention's formation, I suggest, and Sir Gerald did allude to this in extrajudicial writings, it means that there should be a strong presumption that the court will construe the text of the Convention and intent of the adopters in a manner consistent with the demands of the natural law. So I think there are several advantages to this approach. It will help curb judicial lawmaking and usurpation of signatory states' authority. It would help uproot decades of poorly reasoned jurisprudence that functionally make it nigh impossible for a member state to construct or to maintain an authentically Christian democratic polity, to protect traditional marriage as the foundation of the family, uphold orthodox Judeo-Christian teachings on human sexuality or the value of life, and to allow a state to robustly protect its territory, borders, and traditions. The current jurisprudence makes that a lot more difficult. But this is the gloomy note I'm going to end on. So I've offered this alternative approach. But the pessimism comes from the fact that I'm entirely aware that trying to pry the main institutional actors that set the strategic direction of the court, judges, registrars, jurisconsults, away from the living instrument approach, which has so defined their identity. It's a Herculean task. And the sheer difficulty inherent in trying to shift the court in a direction more consistent with text, intent, and underlying philosophy of the Convention might well serve to sharpen arguments for disengaging more completely from Strasbourg jurisprudence and the European Court's jurisdiction. For, if courts, both home and abroad, regularly make de facto amendments to the treaty by judicial lawmaking, amendments which are also not conducive to genuine human rights and goods, then the intelligibility of binding ourselves to the treaty and its commitments dissipates considerably. Perhaps for us Europeans today, to follow our consciences should mean leaving the court and its lawmaking behind. Thank you.
Gonzalo?
Well, first, I want to thank all organizers for inviting me to participate in this event, where scholars from different parts of the world have had the chance to meet and discuss on natural law issues in real life context. The title of this presentation is Natural Law and the Issue of Deference in Regional Human Rights Courts. One of the most frequent challenges faced by regional human rights courts, such as the European Court of Human Rights and the Inter-American Court of Human Rights, is the issue of deference. These courts functioned as institutions of subsidiary authority, adjudicating cases that national courts either fail to address or do not address properly. Therefore, for an application to be admissible before regional human rights tribunals, the applicant must have first exhausted all available national remedies. Naturally, the principle of subsidiarity is behind this procedural requirement. The jurisdiction of regional human rights courts is complementary because the institutions of the states have the primary responsibility to address any situation that may eventually represent a human rights violation. However, subsidiarity is not only about procedure. There is also a substantive aspect to subsidiarity. According to Professor Samantha Besson, quote, substantive subsidiarity qualifies the intensity and content of the review the International Human Rights Court may exercise once the conditions imposed by procedural subsidiarity are fulfilled and it is allowed to exercise its review power. End of the quote. Substantial subsidiarity acknowledges that interpretation of international human rights law can differ depending on the national context. Consequently, regional human rights courts should rely on the decisions of domestic authorities when they are in a better position to resolve the issue. While the European Court of Human Rights, at least formally, accepts that subsidiarity requires to show some level of deference in some areas to state decisions, the decisional body of the Inter-American Court of Human Rights shows a different approach, in which subsidiarity, in practice, has only a procedural dimension. Indeed, the Americas Human Rights Tribunal has progressively refused to pay deference to states by rejecting the use of the margin of appreciation. Despite the position of the Inter-American Court of Human Rights on this issue, most scholars acknowledge that the principle of subsidiarity has both procedural and substantive aspects. However, there is no consensus on when tribunals should grant deference or how much deference should be afforded to states. This presentation does not aspire to resolve this problem. Nonetheless, it will aim to identify the areas in which deference should be considered by regional human rights courts. To achieve this, I will apply a distinction commonly found in the structure of most human rights conventions, which differentiates between the language of prohibitions and the language of rights. Despite their differences, it is remarkable how similar regional human rights conventions are in their structure. Regarding their normative density, their provisions form a sort of continuum, ranging from very broadly articulated provisions to more specific ones. The provisions that are at the thicker side of the continuum are those that tend to focus on duties rather than rights. In general terms, they prohibit states from engaging in conduct such as arbitrary killings, torture, or human trafficking by using the canonical form, quote, "no one shall be," end of the quote. An example is Article 3 of the European Convention, which declares that, quote, "no one shall be subject to torture or to inhuman or degrading treatment or punishment," end of the quote. However, provisions that employ this language of obligation are relatively few in human rights conventions. Most guarantees protected by these treaties are expressed as underdetermined rights. These provisions simply state that, quote, "everyone has the right to certain things, such as free speech, privacy, honor, property, and so forth." In my view, Professor John Finnis was one of the first to recognize that the common structure of human rights treaties was not merely, quote, "a logical ineptitude or stylistic variation," end of the quote, but one with meaningful implications. Indeed, this distinction is well rooted in the principles of natural law. All human rights conventions include limitation clauses designed to impose restrictions on rights. For instance, Article 32 of the American Convention says that, quote, "the rights of each person are limited by the just demands of the common good in a democratic society," end of the quote. These clauses, despite their technical weaknesses, allow national authorities to delineate the boundaries of conventional rights by assessing what are the requirements posed by the just demands of the common good on the exercise of individual rights and freedoms. As affirmed by these limitation clauses in both the European and American conventions, they apply only to provisions concerning, quote, "the rights of each person," American Convention, or, quote, "the rights and freedoms of each person," end of the quote, the European Convention. In other words, limitation clauses only apply to rights-based provisions. Therefore, they cannot be used by states with the purpose of restricting the enforcement of conventional prohibitions, which do not grant rights or freedoms, but rather impose duties on states. As a result, states cannot invoke the demands of the common good, whatever they may be, to justify breaching their conventional duties. Indeed, this set of prohibitions cannot be suspended even, quote, "in time of war, public danger, or other emergency that threatens the independence or security of the state," end of the quote, as Article 27 of the American Convention specifies. This reading is consistent with natural law principles that affirm that there is a set of intentional behaviors whose objects are always morally wrong, like arbitrary killings, torture, or slavery. In this context, the terminological distinctions within human rights conventions play a crucial role in defining the normative force of their provisions. While provisions framed as "everyone has a right to something" carry a more directive force, because their content is often underdetermined, those framed as "no one shall be" possess a conclusive force. Well, the significance of this distinction between rights-based provisions and absolute prohibitions extends even further. In fact, and this is the proposal, supranational judges must consider the existence of this distinction when adjudicating human rights cases, especially when resolving whether to afford deference to the state and to what extent. All rights recognized in human rights conventions aim to protect various aspects of the human good. These treaties seek to establish a legal framework within state parties that enables individuals, families, and intermediary bodies to flourish. This is basically the final goal of each human rights convention, to safeguard critical aspects of the human good within domestic communities. Now, the structure of these conventions seeks to achieve this objective in different ways. Concerning rights-based provisions, conventions require states, quote, to adopt, in accordance with their constitutional processes and the provisions of this convention, such legislative or other measures as may be necessary to give effect to those rights or freedoms, end of the quote, as pointed out in Article 2 of the American Convention. In other words, state authorities must translate these vague treaty provisions into rules and standards that are sufficiently defined to guide action within the political community. This not only aims to orient the actions of citizens, but also to impose clear limits on what national authorities can do. This interpretation is fully consistent with one of the main principles of treaty interpretation, which is to give treaties a reading that enables them to fulfill their object and purpose. This because translating these rights-based provisions into a defined set of rules and standards is the only way in which states can ensure effective protection for right holders. This process of construction closely resembles what Thomas Aquinas referred to as determinatio. Determinatio is, according to Professor Finis, quote, a non-deductive intellectual process, end of the quote, by which positive law is derived from basic human goods as matter of implementations of general directives. It involves in specifying or concretizing basic human goods through law in a non-deductive manner. Rights constructed through determinatio represent contingent choices made by rational authorities guided by basic principles. During this process, authorities can concretize different human goods in various reasonable and acceptable ways. The normative variations that arise from this process reflect the richness and diversity of human communities, each with its own identity, history, and culture. However, the nuanced relativism of determinatio does not overshadow the reality of provisions framed as prohibitions in international human rights conventions. Even though they require a process of determinatio for full enforcement within domestic communities, these provisions are grounded in the language of obligations. As a result, its definition is clearer than that of rights-based provisions. While rights-based provisions can be implemented in various ways that are acceptable from the perspective of the common good, the scope for interpreting prohibitions is more constrained. In these areas, determinatio cannot permit states to evade their duties in good faith. The underdetermination affecting conventional rights provisions serves a specific purpose. Because of the vague scope of these provisions, their enforcement supposes further determinatio. Even though both states and regional courts can engage in this process of determinatio, the principle of subsidiarity gives to the state the primary responsibility to address this issue. In this respect, the court's role is ancillary, not substitutive. It is at this point precisely that the realities of subsidiarity and determinatio intersect. Since determinatio may lead states to adopt different and even conflicting approaches to rights implementation, regional courts should be cautious in condemning states in this area. They must carefully handle cases where the broad latitude of a rights-based provision allows national authorities significant discretion. In such cases, regional human rights courts should not engage extensively with the substance of the issue in debate, but instead, in my opinion, focus on assessing the reasonableness of the state's decision. Conversely, when dealing with provisions that impose negative obligation on states rather than defining rights, regional human rights courts can be less deferential. Despite the need for domestic determinatio, These provisions are drafted with enough precision to identify the core of the state conduct that is strictly prohibited. Given the specificity of these provisions, states can understand in advance that they cannot intentionally engage in a series of actions which are always morally wrong, regardless of the circumstances. In this context, it seems reasonable for courts to apply a more stringent level of scrutiny to the state, considering both the provision's normative capacity to guide state action and the gravity of the offenses that those behaviors imply. This approach is also consistent with the basic purpose for which regional human rights systems were developed, to prevent states from unjustly killing, torturing, or enslaving their citizens, as totalitarian and dictatorial governments had done in the past. Finally, it is important, as Conor pointed out before, to clarify that this stricter form of scrutiny does not permit regional human rights courts to extend the narrow scope of these prohibitions beyond its intended meaning. In conclusion, the structural distinction highlighted by Professor Finis in Natural Law and Natural Rights is valuable not only for demonstrating the correspondence existing between the moral imperatives of natural law and the text of regional human rights conventions, but also for providing a framework to analyze regional human rights judicial scrutiny. This distinction between rights-based provisions and absolute prohibitions underscores that some actions are fundamentally impermissible for the states, which supports a more rigorous and less deferential approach by regional human rights courts in assessing such actions. Conversely, for rights-based provisions, a more deferential approach to review is not only justified by the demands of determinatio, but also required by the principle of subsidiarity. Finally, this distinction clarifies the interplay between determinatio and subsidiarity inherent in any international human rights convention. Thank you so much.
Now we open the floor for questions. Yes, please.
Thank you. So you seem to advocate exit. But my question is whether you think there's a prospect for a form of legitimate selective exit equivalent to opt-outs from the European Union that Ireland and Denmark and the UK during membership enjoyed, which could be created through reservations in protocols to the convention. Thank you.
That's a great question, and I think that particular approach has been advocated by people like John Larkin, who was the former Attorney General of Northern Ireland. He suggested some form of reservation whereby after a judgment, a member state could say not quite on board with that expansion of Article 8. There's a lot of practical problems with it in terms of getting people on board, and if you agree with, say, Sir Gerald Fitzmaurice's view that Article 8 that horse is bolted since 1979, then that's a lot of reservations you're going to have to make. If you disagree with the foundation of the jurisprudence, then it's just going to be, at some stage, the Council of Europe member states might turn around and say, what are you doing here? You don't agree with any of this. Why don't you just, leave? So I think that it is an option if you accept much of what the court does in its approach and methodology, but you don't like a particular expansion, say, into the realm of climate litigation. But if you think root and stem, a lot of the approach is bad. It's just such a, you're just going to be constantly reserving, and you might think, well, what's the point in having the supervisory jurisdiction if you think most of the doctrine is faulty? So that's what I would say to that.
Thank you.
Yes, please.
Conor, I was interested in what you said about Judge Fitch-Morris insisting on paying attention to the scope of Article 8 and not just jumping to the interference level. And I was just wondering, did he develop that at a kind of systematic approach, either in terms of wholly critiquing the two-step approach and saying we should just focus on the scope, or perhaps addressing what Gonzalo referred to as the potential ineptitude in the drafting itself, which at least kind of gives hostage to fortune and inviting focus on the limitations?
In the full run of his dissents, I think you can piece together a picture which shows that, you know, he saw that threshold question as extraordinarily important. Discerning whether was in the ambit was of central importance to him, and that's where two things helped him determine that. In his judgments and dissents, a lot of it is reflecting on sort of like construing a statute in at least in the UK type legal systems, where reflecting on the mischief that was sought to be, what did the statute try and solve or resolve? What was the problem before? And a lot of that is the immediate context of the drafting. A lot of it's the war period and the atrocities. War period, and then the Soviet occupation of Eastern Europe. Those things loom large in his mind, and he refers to those in a few cases as the context in which to construe the sort of threshold of certain things like Article 3 or the scope. You know, it's not everything touching on family life. It's the aspects of family life that were trampled upon by fascists, communists, and things like that. That's one part. And then in his extrajudicial writings, he basically says, I see the convention as a sort of specification of the basic axioms of the natural law tradition. You know, this is a baseline from which no civilized state can, you know, fall from. And if those, you know, the court has sort of said something along the lines of, if we don't keep evolving the legal content, that the convention will become redundant. To which Sir Gerald would say, there's nothing redundant about everyone not torturing people. You know, if everyone lives by that baseline, that's actually a great good, and that's the point. The fact that we have no cases before the courts, a good thing. It means there's no one torturing anyone. So yes, so reflection on this socio-historical context of the war period and reflecting on the convention as an instantiation of the natural law tradition. Those are the two things he brought to bear on along with the text and structure, to try and discern the scope of a provision.
So I have a follow-up question about this, and then a question for both of you. Is it okay if I ask? Okay. So my follow-up question about that, Conor, is I understand what it might look like for the court to try and focus on the mischief in the text and the structure. Those seem like familiar interpretive tools to me. But the other piece you're talking about of recognizing that instrument is a specification of axioms of natural law, how would that look as an interpretive tool, say, in like, you know, one of the court's recent cases, if they were using that to drive their analysis in the climate change decision or something like that? How might that shift their analysis separate from text or mischief and structure? And then a question I'll pose to you both is, Jack Balkin at Yale recently made the argument in his book about constitutional memory and authority that one critique of the living instrument or living tree approach has been made that it creates tension or pressure with democratic principles. And his response was, well, a lot of democracies are doing this in Europe and Canada, and so that obviously means there's not tension with democracy because they're democracies and they're embracing this living tree approach. So I'm curious if you have thoughts or what you would say in response to Jack Balkin about that.
On the what would the relevance to the climate judgment? It might be in a sort of via negativa. It might be, you would say, well, the convention is a specification of, you know, the baseline of protection for the person and the family against, you know, atrocities and barbarities and tyrannies. So the context of Article 8, privacy, you know, that's relevant to discerning the scope. It concerns the family domain and protecting it from the state. So if you go by that approach, then it's just got nothing to do with the subject matter of whether the state needs to regulate carbon emissions. You know, it's just so far reflecting on the historical context and it as a specification of, you know, basic protection of basic human goods. That takes it very far from this very contested policy question, which is now being jammed into Article 8. On the democratic principle approach, I mean, one problem with arguing that what the court's doing is anti-democratic, I don't usually use that argument because I talk about in terms of in principle usurping authority that's not been given to it. But in terms of democracy, most people don't care. You know, most people do. You know, most people care if the result looks good. If the court rules against your government, you don't like your government, then you'll say that's really good. And if you don't like it, but in terms of democracy, I don't think it doesn't aggravate a lot of people. I would say, which is maybe unfortunate, but I wouldn't lead in terms of democracy type arguments. Gonzalo?
Yeah, I think that the problem with the living tree interpretation is that, in my view, you know, like the living tree interpretation in regional human rights courts is not just like a sort of new form of interpretation for courts. I think that the meaning of the meaning, you know, like the implications of this kind of interpretation goes beyond. You know, it's a kind of, now it has become a part of like the legal ethos or international human rights law. And this sort of ethos finally, you know, constrains, you know, like the application, for example, of the idea of subsidiarity. You know, everybody says, you know, no, there's no problem. You know, like at least in Latin America, for example, in the debates in the Americas, is, you know, the American Convention recognizes, you know, like the subsidiary nature of the system. So what is the problem? But the issue is that when you have this sort of legal ethos, you know, a legal ethos built from this idea of the living tree interpretation, for example, this sort of ethos really limit the way in which you can, for example, apply the principle of subsidiarity. And this form of interpretation, you know, it's not just, you know, again, this is not just about interpretation. You know, it is about giving to courts the legal power to go beyond the text or even against, you know, like the text. In the Latin American experience, you know, in the Americas, you know, every time the Inter-American Court, for example, has had to go not just beyond, but against the specific text of the convention, it always, you know, appealed to the idea of living tree interpretation, evolutive interpretation, and so forth. So I think that it's one of the main problems, that now this form of interpretation has become really like an essential part of this legal ethos in international human rights law.
Thank you, Gonzalo. I'm going to go in the order of the previous round. I saw hands up, and perhaps we can take 3 questions at a time and see how you fit the answers together. There was Professor Finis, you wanted to ask a question?
Hello. Yes, I just two observations. In describing Fitzmaurice, I think it would be helpful just to add a phrase to indicate that he was a great expert on treaties and treaty formation. I think he was involved in the preliminaries to the Vienna Convention and so forth in the Foreign Office, and that formed part of his, a considerable part of his formation as a lawyer. And I think, if I remember rightly, he appeals to the accepted doctrines of treaty interpretation in the development of his critique of the court's living instrument, etc. In respect of Gonzalo Candia's paper, a general observation about the thought that's been expressed a number of times here that duties are prior to rights, or of greater importance in some sense in forming a culture or sound morality, public morality. I have some reservations about that because I think analytically and logically duties and rights are strictly correlative, and so if there is a duty to somebody, then there is a right possessed by the beneficiary of that duty to something equivalent in content to the content of the duty. So that's a general observation. I'm sympathetic to the thought that duties are prior to rights, but I have a little polemic paragraph against that thesis in natural law, natural rights, and I think it's right, the paragraph. But on Gonzalo Candia's paper, I think at the very end, the word negative was inserted in front of obligation, but I think it should have been up near the beginning. The contrast, I think, is not so much between rights and obligations in the drafting of these human rights conventions, but between negative strict obligations and the rest. And the rest may be formulated in terms of affirmative obligations or rights, and sometimes the two are mixed together and so forth. So I think you got there, but it might have been pushed up a bit higher.
Thank you. Shall we take two more questions? There were hands in the back of the room before. Yes? Yes, please.
Okay, thank you both. This is a question for Gonzalo. So the debate is usually framed in terms of justice. So I'm curious about what you said at the beginning of who is in better position to judge. One may argue that being in the context of the conflicts and being part of that community makes you puts you in a better position in terms of justice to decide some issues. But you can also say, well, the perspective, the distance of international courts gives you something that the courts within the community don't have, and that may be a just result. So I was wondering if there is a requirement of justice in the physical closeness, so to say, or if the debate is just misleading in the sense that subsidiarity and the determinatio decisions made by states already satisfy or are forms of instantiation of justice. So the question is whether there is, if there is a requirement of physical closeness or property in the decisions, if there is a requirement of justice in that sense, or if, as a second question, if the debate in those terms is just a false dichotomy. I don't know if it was clear. Thanks.
Perhaps we can go there. I think we have just enough time to answer these two questions. I'm sorry with the other hands.
Well, answering to the observations of Professor Finis, I think there is naturally this kind of distinction. It is, kind of artificial. You know, you have a right, then you have a duty. You have a duty is because you have previously a right. The only, you know, like purpose of focusing on this, you know, like linguistical distinction is just to have a kind of justification to argue in favor of a more differential approach in the areas of determinatio. You know, in determinatio, you know, both states and courts can engage. I mean, but again, you know, it is in this area where determinatio comes, where subsidiarity says, okay, both can engage in determinatio, but states have this normative primacy. You know, they have, like, according to subsidiarity, at least they have, you know, like they are the first called to define, you know, to resolve many of these conflicts that also are not just legal in nature. That's the whole thing. I mean, many of the human rights conflicts that come to regional human rights courts, I think in Europe, both, you know, like in the Americas as well, they are more like political in their nature. And so in this area, you know, or in this context, the idea of subsidiarity is even more powerful. You know, so that's the thing. And regarding the issue, the question of Mariana, I think that subsidiarity is just you know, like behind subsidiarity is the whole issue of justice. I mean, you have communities that are able to resolve, you know, like problems by themselves. So why, you know, like a bigger community, you know, just jumped to resolve something that domestic communities can do? And yeah, the argument that, okay, you know, from an international court, from an international point of view, you have, you know, like a less partiality, you know, a kind of impartial, you know, arbitrator or something like that. Yeah, it you know, like this idea has appeared in some decisions, you know, like at least I know from the Inter-American Court of Human Rights, this idea that, okay, we are in, you know, like states is not in the best position to resolve because we are more impartial. You know, states is so involved. But I think that this is not like what subsidiarity means. I mean, subsidiarity demands communities to assume their own responsibilities. You know, this is the whole issue. The issue is responsibility. You know, political responsibility, the responsibility within the political community. This is not about granting privileges to states or political or domestic communities. The issue is that they have a responsibility. You know, a responsibility not just before their citizens, but also before the rest of the international community to resolve the issues that they can do by themselves. So this is, I think this is the thing. You know, it is subsidiarity is about thinking on terms of justice, you know, political justice.
Thank you, Gonzalo. Just briefly, I think we're out of time, but Conor, do you want the last word on the questions, comments?
I don't think I could improve on that.
Thank you very much. Thank you, everyone. And I think now we have time for a coffee, and then we go to the second part of this panel.